Welcome back to Legal Threads. I'm Chat, and today we're heading to Wyoming to look at a case about self-defense, jury instructions, and where the law draws the line between protecting yourself and going too far. This is Tatman V Cordingly. The story begins in June of 1982, on an isolated road in Albany County. On one side was Tatman, a 66-year-old man with a reputation for a temper and for carrying firearms. On the other side was Cordingly, in his 20s, riding a motorcycle. What started as a dispute escalated into a violent confrontation. Each claimed the other was the aggressor. Tatman ended up seriously injured, hospitalized for 8 days with heavy medical bills. He said Cordingly assaulted and battered him. But Cordingly insisted he acted in self-defense. He described Tatman as the one who ran over his motorcycle, struck him first, and even tried to grab a rifle during the struggle. The trial came down to a classic tort law question. When is self-defense a shield against liability? The rule is that self-defense requires two things. First, the defendant must honestly believe they need to use force to protect themselves. Second, that belief must be reasonable under the circumstances. And the force used must stop once the danger has passed. If both parties voluntarily agreed to fight what the law calls a mutual affray, then both could be liable. But if one side reasonably acted out of fear for their safety, self-defense applies. At trial, the jury believed Cordingly's story. They found his actions justified and ruled in his favor. Tatman appealed, arguing that the judge gave the wrong jury instructions and that no reasonable jury could have sided with Cordingly. But the Wyoming Supreme Court disagreed. It said the instructions as a whole correctly explained self-defense, and the evidence was strong enough for the jury to conclude that Cordingly acted to protect himself. The judgment stood. No liability for Cordingly. This case matters because it shows how self-defense operates in civil law. It's not enough to simply claim fear, the fear has to be reasonable, and the response proportional. It also reminds us that courts defer heavily to juries in messy factual disputes. Tatman v. Cordingly draws a clear line: self-defense is a shield, but only while the threat is real and immediate. Once the danger is gone, the privilege ends. And that's the thread for today. Please like and subscribe for more legal threads.